We will hear argument this morning in case 2512.
Grievances we could go into with this system. I think we could be here for hours.
National Collegiate Athletic Association.
I think we have some proof, even a few years into NIL now, that people care about the logo.
There are too many people in power who have no desire to give up that power.
The NCAA's ever-shifting decisions, not stable decisions.
Does the concept of amateurism in college athletics even matter anymore?
They've capped it again without any sort of collective bargaining.
We'll finish with our unilateral decision. Hey everyone, welcome to another episode of Unilateral Decisions. Today, we're talking something that came through earlier this week, House versus NCAA Class Council. And before we get there, I want to go back to multimedia rights companies, what they do, and historically what their role has been in college athletics. So we're talking Learfield, JMI, Playfly. Mike, we'll start with you since you've worked with them plenty. What historically have those entities done for colleges across the country?
I think the simplest way to put it is that those outside groups have come in and schools have identified them, individual schools, conferences in some cases, have identified one of these groups to be the intermediary that they take essentially a guaranteed payment from to then take the rights to monetize the athletics logos and facilities and the assets surrounding athletics from a corporate standpoint. So, there's examples all over the place, but the digital boards that you'll see behind the benches on a football field, recently the jersey patch things have come into play where that's now an option for these groups, for the schools to monetize. So basically it becomes an NCAA rule that it's allowed for the schools to monetize space on the jersey or space on the football field, which previously was prohibited. And then most schools have contracted those services out. And most of them do it in exchange for a guaranteed payment and then some form of revenue sharing. Some have, there's been different situations over the course of the years where it'll ebb and flow. Some schools want to take it back in-house. Some schools decide that taking it in-house was the wrong choice. And a lot of it comes down to the guaranteed money. A lot of it comes down to, honestly, and Joe knows way more about this stuff than I do. He was much more involved at the university level with being the liaison with the MMR partner. But oftentimes, I think that the choice comes down to whether or not you get some built-in firewalls when you have it external, when it's a third party, where it's a lot easier for a school staff member to kind of, do a little bit more horse trading rather than like holding the line when a Learfield or a JMI has paid a certain amount of money that they have to get a return on. And they're making sure that they're not just doing favors to get some of those things paid back. Whereas when it's the school, you can kind of do a little bit more creative accounting to be able to get some of those things done. So, but generally speaking, that's what it is. It's those corporate rights attached to athletics, marks and assets that someone is going out and monetizing, and generally the schools have outsourced that.
And then, Joe, the evolution of that, NIL was never a part of that purview with multimedia rights companies. Now it is. So how has that shifted? Maybe early on, what were some of those views from these multimedia rights companies as far as how do you deal with or ignore NIL?
Well, it's not unique, having something new become part of the contract. Previously there were MMRs and there was no social media. So there's clauses in these contracts that, any sort of new, ability for marketing assets that comes to fruition, belongs to your multimedia rights holder as well. And like Mike said, it's in its simplest form, an MMR is coming in and guaranteeing money in exchange for the marketing rights, the use of the logo. So you've got, business out there that wants to be attached to the institution. And so they throw the logo on and say, we support this school. Well, you have to pay for those rights as a business. You can't just throw a school's logo or an athletic logo on one of your advertising vehicles and say, because I'm a season ticket holder, I support this entity. I mean, it's expensive to get involved in a lot of places with a multimedia rights holder.
Pay for that affinity.
100%.
Yeah.
You want to affiliate with that institution because of the fandom, right? And so to affiliate your brand with that brings value to your business. And so, one of the things I had to be the guy at times send emails and say, hey, you can't do this, or pick up the phone and call a business and say, hey, sorry, you can't do this. And so what you're seeing now with NIL specifically, and that reminds me that you actually asked a question instead of me continuing to just explain what Mike explained. NIL, you'll see a business want to attach themselves to a student athlete, which is what NIL always was, right? But I think one of the first things Mike said on this show is that there's value in the logo. So if you are paying for multimedia rights, or you are paying for multimedia NIL rights, you will see your business with a student athlete in their uniform with the logos on it. A lot of businesses are doing that without paying for those rights. And so you'll get a phone call and say, hey, you can't do that. So now you'll see somebody in their full uniform with the logos scrubbed, and you're like, what is it? That looks terrible. But that goes back to what Mike said at the very beginning. There's value in the logo. So now going back to your question about how did NIL change the MMR picture, I think MMRs were a little slow to get in this and see how this was going to play out. And so early on, it felt like they weren't really touching it. And that could be because, schools weren't allowed to, pay athletes directly until the House settlement came into play. But once things started to formulate and kind of fall in place, you saw MMR step in, and you can be a corporate sponsor, but then you can also pay for NIL rights. And once you've paid for NIL rights, then you can use student athletes in their jerseys and in institutional marks. And so they've started to adopt that. And honestly, I think that's created a lot more value for multimedia rights holders. I think the student athletes have value, but I also think the logo is powerful. But that creates, a new class of sales for multimedia rights holders.
Yeah, in my interpretation, and based on you look at some of the filings that were made, and the plaintiff's motion that was made in the House settlement this week, and you look at really specifically at what the College Sports Commission's response to it was, and because you had in that motion you had a few attachments, including a letter from the College Sports Commission that kind of explained, kind of pushed back against the class council's kind of saying, hey, you're taking this way too far. You're not supposed to be, reviewing these deals. You're not supposed to be kind of, subjecting these deals to kind of this more specific interpretation. And the College Sports Commission specifically pointed to, really, in a lot of ways, kind of the idea that a lot of schools are ring collectors in-house now, where previously we had these NIL collectives, or we still do in a lot of cases, but we have these NIL collectives that are run by boosters in a lot of cases, and their sole and primary purpose is to sole and or primary purpose I should say is to create NIL opportunities for athletes. But a lot of schools are bringing those in house, and what they're doing, and they point to specifically they point to PlayFi's relationship with LSU. One of the examples they give where PlayFi actually created in-house and kind of, and staffed it at LSU, and it's run by PlayFi, but it's at LSU, kind of part of LSU, specifically targeted towards LSU athletes, this NILSU initiative, this new program that is designed to, create NIL opportunities, using PlayFi's assets, using their relationships for LSU athletes. And that's what's kind of, that's kind of one of the clearest examples of the College Sports Commission saying, hey, wait a minute, this is actually something that should be covered within the House settlement.
So this lawsuit at its crux is MMRs challenging NIL Go, the CSC, and saying our deals should not be subject to review.
Basically, yeah. And it's all about interpretation. Because really, at the end of the day, I think it's kind of a misnomer. I think it's kind of, one thing about the House settlement that I don't think was made really terribly clear is that not every NIL deal is actually subject to the College Sports Commission to NIL Go's review, where they're reviewing things for fair market value and they're reviewing things for, is it a valid business purpose? And I actually have the text of the House settlement right here. It only applies to associated entities and individuals, which includes any entity that is or was known that should have been known to the athletics department or staff or member institution to exist in significant part for the purpose of promoting or supporting a particular member institution's intercollegiate athletic program or athletes. So NIL collectives, these new entities that have popped up in the wake of July 1st, 2021 to, provide to funnel money to athletes through NIL opportunities or to create NIL opportunities or to do it through charitable initiatives or anything like that. It includes boosters who have contributed more than $50,000 over the lifetime. It includes athletic department staff or anyone who's been directed by athletic department staff to participate in the recruiting process. And so it's all about that interpretation. It's all about, are these MMR companies considered to be these associated entities and individuals because of the relationship with the athletic department? And that's a question where clearly it's not even the MMR companies that are challenging this. I mean, maybe they are kind of through back channels, but it's actually class counsel. It's the plaintiff's lawyers. It's Jeffrey Kessler and Steve Berman who are stepping in and saying, hey, we have this special master, magistrate judge Nathaniel Cusson, who was appointed to resolve interpretive disputes regarding the House settlement. We want him to step in here and resolve and make a ruling saying that MMR companies are not subject to this.
So this is a fascinating thing because I think if you talk to most people that work at Learfield at those local levels, they're going to feel like they're a part of the athletic department. They're taking part in meetings with leadership for the athletic department. But part of the motion argues that multimedia rights organizations represent hundreds of schools across the country. Their vested interest at the local level is low because they've just got themselves spread across everywhere. So where do you line on that? Do these multimedia rights companies have a vested interest in the school? Should they be an associated entity or not?
So I have a couple thoughts on this. I think that the can of worms that this opens is that the House settlement and we've talked about the $20.5 million and the escalation on that and whatever that looks like, explicitly not being pay for play. And so if you are to take that at face value and the schools are going to then pay the athletes up to the $20.5 million cap and then have an expectation that money coming through MMR partners is on top of that, which I think is where a lot of this comes from, I get there's a little bit of a disconnect there for me in that the school is monetizing the athletes' NIL rights, but they've already contracted out monetizing their own rights. And so if you are contracting out, if you're going to give the athletes $20.5 million and say it's not pay for play, then what is it? If you also want MMR partners to be able to monetize their rights on top of that, because if you're putting them on schedule posters and you're running them through the car wash of your internal media team, that all of those advertising components and assets are sold by your MMR partner, how are you monetizing the athlete's rights? At least up to that giant threshold of money. I mean, maybe you can make an argument here and there that you've sold some tickets and you've got some other things going because the athlete showed up somewhere and there wasn't a company attached to it. But so much of the value of that comes from attaching companies to it, which is what the MMR partner is supposed to do. And so I think to me, that's the crux of the issue. I get the point of the MMR not being an associated entity to the, definition that you talked through and what you read, completely understand the argument there. But I do feel like it kind of flies in the face of, okay, if the MMRs are going to be additional, then how is there actually $20.5 million worth of value that's not pay for play for you to pay the athletes? And so that's a challenge for me. But I mean, Learfield just got bought by a private equity company, and private equity companies historically don't buy entities to be charities. And so, I mean, I don't think there's actually that big of an issue. And that's why I also don't think Joe's question was about if MMRs are pushing back on this. I don't really think they are. In my experience, there's only a few. Playfly is pushing because they're trying to build market share. Learfield is the leader as far as like volume. And Playfly is pushing by trying to be creative to find these solutions at LSU. They're doing similar at Texas A&M. They've got a couple others that they're standing up across the country that they're coming in and saying, we'll be this solution also, where Learfield has been a little bit more hands-off on some of those things. And I think that they're not the ones pushing, for this motion. I think it's the plaintiff saying there's more money to be had.
Yes.
So anyway, that's a lot, but I yeah.
And Sam, you mentioned earlier the NIL Go review. Walk me through what that is, because if I'm a consumer watching college sports, it doesn't seem like there's any review going on. It's just checks being cut left and right. So Where does that come from, and what has it done thus far?
Well, there clearly is an NIL Go review going on because we have this dispute now, and this dispute, it wasn't necessarily mentioned specifically in the motion, but it's pretty clearly tied to kind of similar disputes that Ross Dellinger at Yahoo Sports has reported on at Nebraska and a few other schools as well. Texas was also mentioned in the letter from the College Sports Commission that was included in these exhibits. So what we're talking about here is under the House settlement, third-party NIL deals. It's one of the kind of the three planks of the House settlement, along with roster limits and revenue sharing provisions. The third plank here is that third-party NIL deals that are made with, made with associated entities and individuals, so collectives, boosters, athletic department staffers, third parties who can be reasonably interpreted as kind of within those buckets, which is the whole dispute with MMR. Any deal that's made with them, with an athlete as a third party NIL deal that's not directly with the school, has to be subject to NIL Go review, which is to say that it's going to be subject to review for determining whether it is fair market value, which they actually changed that language, I should mention, to reasonable range of compensation, which is to say it's not so wildly out of whack where it's very clearly like we're paying them to be at the school. It's something that actually aligns to what what the value they're receiving in return is. So it was like, you're paying them to make 5 social media posts. Well, if you're paying them $1 million to do that, that's probably, unless it's a really, really, unless it's an athlete with a really high social media following where the value of those social media posts is a ton of money, it's going to be something that's going to be flagged by the NIL Go system. They're also looking at it to see whether it's for a valid business purpose, whether you actually have in the deal kind of a quid pro quo that is, in fact, you're paying them to do something that's actually going to support the business, that's actually going to support the third-party business in this relationship, where it's giving them something of value as well. And that again goes to kind of this reasonable range of compensation as well, where, again, it's not pay for play. And that's something where, for example, early on, the College Sports Commission, basically, not basically, but literally said all deals with collectives are not for a valid business purpose, because our interpretation is that NIL collectives only exist to kind of just funnel booster money to athletes. They're not actually getting anything in return. They don't want anything in return. So that's not for a valid business purpose. House Settlement Plaintiffs pushed back on that. College Sports Commission rescinded that to a certain degree. But again, another subject of controversy here. So it's all about that review. It's all about this fair market value and reasonable range of compensation review. It's all about the use of, the College Sports Commission. They created in alignment with Deloitte, an algorithm that kind of estimates this fair market value, estimates this reasonable range of compensation. It's all about whether it's subject to that review and whether these third parties, the MMR companies, are going to be limited in, what they're allowed to do with these athletes.
This all leads into antitrust, something that gets mentioned on every episode we've had. The NCAA has been asking Congress for antitrust exemption for 25 years. Why?
Sam?
Well, because there's a lot that is subject to antitrust review right now. I mean, if you look at, and they've been asking Congress for an antitrust exemption for a while, because I think they've seen a lot of this coming, but really a lot of this is picked up in earnest since the Alston decision, which of course we talked about several times on this show already. 2021, where the Supreme Court ruled 9-0. Not only that, the injunction that was in place, that was put into place by Judge Wilkin in the district court, that said that the NCAA cannot limit education-based compensation to athletes, things like postgraduate internships and laptops and things like that. Not only upholding that, but also saying the NCAA is subject to antitrust law. They're not immune from antitrust laws. They want to be. Their amateurism rules are not immune to antitrust law. They have to go through the full, what we call ruler reached analysis, which is this very long drawn out process that requires a lot of economic analysis. It's not just, from the start saying the NCAA, their amateurism rules are not subject to antitrust review. And since then, of course, we've seen the Ohio case, which was about transfer portal, that ruled that the year residence rule could not be enforced. We saw the Tennessee case, which ruled that the NCAA's restriction on pre-enrollment NIL negotiation also cannot be enforced. We've seen eligibility cases that are antitrust based. We've seen all these different things where the NCAA rules are really being picked apart one by one on antitrust grounds, saying that it is a restraint on these athletes' abilities to be able to enter into and fully compete in this labor market by restricting their ability to transfer or their ability to go beyond kind of the 4 seasons in 5 years that the NCAA sets forth, and all these different things. So the NCAA is very much looking for antitrust relief to solve all these issues, but also this one as well, because the House settlement, House v. NCAA, another antitrust case. And one important thing when we're talking about this NIL go review, we're talking about MMR companies and really any third party, boosters, booster collectives, the boosters companies themselves. We're talking about restricting their ability to compete in this market as well by having a maximum amount of money that they're able to pay athletes. That's also an antitrust issue as well. The Supreme Court's ruled over and over that maximum price fixing is still price fixing. So the NCAA is also, I'm sure, in the College Sports Commission, they're also, pretty scared at this point that we're going to see an antitrust lawsuit by a third party. We're going to see an antitrust lawsuit by maybe an MMR company, by maybe a third-party booster company, where they come in and say, we are not subject to the House settlement. The House settlement has release clauses that say that the athletes can't sue over this. We are not subject to that. We're not restricted to that. We don't sign away any rights over being able to sue. And I think it's especially when we're talking about algorithmic price fixing, which has been a subject in a lot of other cases over the past few years, I think it's a case that the third parties could conceivably win.
In my day job, this actually comes up. So a lot of our deals on the college sports collectibles and trading cards, depending on how the school interprets the situation, is subject to NIL Go review. And we're not an associated entity. We support thousands of athletes at hundreds of schools. But we have run into these situations where in some cases, every school has been a little bit different, and some schools interpret it that an athlete cannot actually do their activation and execute what the deliverables of the contract are until it has been submitted and reviewed by NIL Go. And frankly, I just don't think it makes sense. Like, I don't think that we have a school right now where the baseball trading cards for that school have been severely, severely delayed because the contracts are signed by the athlete, reviewed by their counsel, and approved by everybody. And the licensing component from the school standpoint has been approved, but the school contacts are restricting the athlete's ability to execute signing their trading cards until they have had their deal go through NIL Go. And I don't think that was the intention of what this is, but you've got schools interpreting it that way.
Yeah.
And everyone's a little bit different on how they fall. Some schools don't think it has to go through NIL Go at all, which, according to the way the ruling's written there, makes sense. And some schools think, well, we have this tool, so obviously it has to be used for everything, which I understand the interpretation. But yeah, if that continues to happen to a company that's trying to give an athlete more than a few $100s for some trading cards, yeah, absolutely. There's going to be some legal ground to stand on to say, you can't get in the way of this.
Well, on the MMR, and I have a question, but on the MMR side of things, like you said it earlier, like they just got acquired. These are legitimate businesses. And if if they believe that paying this athlete benefits their, bottom line, like that's a legitimate business purpose, which even if it is subject to review, like how can that get denied? So maybe that's one question, but going back to the antitrust exemption piece, what would qualify an entity for an antitrust exemption? Like if we're fighting for this for 25 years as the NCAA, like there's got to be something close that makes them feel like they qualify, but what would qualify somebody for an antitrust exemption?
And first of all, I want to address what you first said about the MMR companies. I looked back at, and I know, this is kind of a weird situation because there was criminal prosecution over this, but I looked back at the Louisville and Adidas situation from pre-2021, which is actually hilarious to kind of look back at now because people were put in prison for things that are literally legal now, which is really kind of just interesting and funny. Not funny to them, obviously, but just a really weird situation. But if Adidas thinks that even, forget even like the valid business purpose, they're getting some activation part of this back. If they feel like paying an athlete to go to Louisville, it enhances the Louisville brand and enhances Adidas's brand because they're so closely associated with Louisville. Who is anyone to tell them that that's not a valid business purpose? I think that's exactly kind of what you're going for. Maybe a different kind of spin on it, but and I'll go, the College Sports Commission, these are definitely part of the outcome. They're definitely part of these things. But again, these third parties are not subject to this review. They're not subject to the release clause, I should say, where there's nothing stopping them from filing a lawsuit over this and saying, you are restricting our ability. You're getting in the way of our business opportunities. You're getting in the way of our ability to compete in this market. We want a court to look at that. And I think that's something that definitely could come up. And to your question about antitrust exemptions, the courts have been universal in saying there are only two ways to get to an antitrust exemption, or a few others. But when we're talking about these kind of things, there's really two main ways. One would be an act of Congress, where Congress sets forth the antitrust exemption and says this business, this relationship, this kind of thing is immune from antitrust law, or some kind of collective bargaining relationship where you have it kind of folded in where it's something where courts are going to say, we're going to stay out of this because it's a collective bargaining agreement. And we've been told, and in labor law, it really kind of makes clear that courts should stay out of collective bargaining relationships unless you have things like, fraud or bad faith on the part of the parties as they're collective bargaining. Other than that, it's really limited. I mean, you have other kind of exemptions like Nora Pennington, which is based on the First Amendment, which is about like lobbying Congress and things like that, like having trade associations. But largely speaking, like the courts have been very, very firm. Antitrust exemptions are to be, interpreted very, very, very limitedly, and not to be created by the judiciary unless there's, it is clearly tied to something else. With the exception, of course, the baseball exemption, which has survived for over 100 years now. For what reason, I do not know.
If I can, so the MMR stuff, we saw an example of this come up in professional sports over the summer with Kawhi Leonard and the Clippers, where essentially the charge and allegation was that the Clippers were circumventing the NBA salary cap by allowing an associated entity, if you will, a sponsor that had deep ties with the ownership group to compensate Kawhi Leonard above and beyond reasonable means. That is against the NBA's collective bargaining agreement to say, to allow for this sort of ancillary income to come directly via the clubs themselves. Certainly that is on the grounds of collective bargaining. It's allowed, to kind of stand up through that because everybody has agreed on it to a certain degree. Is that an antitrust violation without collective bargaining? How does that kind of compare?
Well, first of all, I'm not 100% sure it's not an antitrust violation even with collective bargaining. I don't think there's been a whole lot of tests of, kind of these ancillary kind of anti-circumvention things where you have a third party filing a lawsuit saying, hey, you're restricting our ability to do that, and this pesky collective bargaining agreement is getting my way. My guess is that because you have the collective bargaining agreement there, because there's so much judicial deference to collective bargaining agreements, courts would uphold that and say, no, it is covered on the non-statutory labor exemption. Non-statutory labor exemption is intentionally very broad because we want to protect these collective bargaining agreements. That'd be my guess. Again, there really, to my knowledge, there really hasn't been any kind of test to that, but maybe we'll see if the Kawhi Leonard situation goes any further. Without the collective bargaining agreement, no chance. It's absolutely an antitrust violation to restrict these third parties' abilities to enter into this market because you have quite literally, if we're looking at antitrust exemptions as contract conspiracies or contract combinations or conspiracies that unreasonably restrain trade. We have an agreement by all the schools collectively and all the players collectively through the House settlement to restrict third parties' abilities to compete in markets, to restrict third parties in this space. And that's a classic antitrust violation right there.
So the settlement alone doesn't kind of exonerate any sort of antitrust action or action that would be, counter to antitrust.
To the contrary, the settlement itself might be an antitrust violation.
Give me an example. Sorry, Dom. Give me an example of an existing antitrust exemption.
The one I like to point to in class is the Fishermen's Cooperative Act, which allows fishermen, commercial fishermen, to fix their prices. That's one that's created by Congress. It's very limited. It's very, very, very small. But one I like to point to in class because it's so kind of random, and a lot of them are created just by trade associations groups saying we need some kind of relief here. We need to be able to do this because of the particulars of our industry. We need to be able to have price fixing in these cases. Another one would be, and one that is really the subject of a lot of discussion in college sports right now, and a lot of discussion in professional sports as well. If you look at all the disputes regarding the NFL right now, and the federal committee, the FCC going after them, the Sports Broadcasting Act of 1961, where Congress stepped in and said, for the NBA, for the NFL, for NHL, Major League Baseball, you are allowed to come. All the teams here, which are separate business entities, are allowed to come together to create league-wide broadcasting agreements with over-the-air networks like NBC, CBS, ABC. You're allowed to do that because we feel like it's best. Because a couple years ago, you had a lawsuit involving the Baltimore Orioles where a court actually said, Major League Baseball, by collectively creating this television package by having, one TV package for the entire league instead of 30 different, or it wasn't 30 at the time, but instead of individual team broadcasting agreements, that's an antitrust violation because you're negotiating collectively instead of individually, which of course is exactly what happened in the Regents case in 1984 because the NCAA is not subject to the Sports Broadcasting Act. So that'd be an example of an antitrust exemption.
So as we put a bow on this real quick, I do have to mention Pablo Torre Finds Out did phenomenal journalism to find out all about this Kawhi Clippers contract. If you haven't listened to it yet, please do. Cannot recommend it enough. I also had to laugh, Sam. You brought it up. I was going to ask you a question about it, but collective bargaining, another buzzword on the show. So if you are at home playing a drinking game, every time we say antitrust or collective bargaining, you're going to have a rough evening. But MMR, it's not measles, mumps, rubella. It is multimedia rights in this case. So as it relates to college sports, MMR, and this House versus NCAA motion, our unilateral decision for tonight or today, who is in the right and why? Joe?
I mean, I don't believe that an MMR is going to long term. Like, I don't believe that MMRs are going to just shell out, millions and millions and millions of dollars for nothing in return. Like, that's not the business that they're in. So, I mean, it's not even the MMRs that are filing this lawsuit. If there's so many pieces to this, like, it's, which side do I fall? I fall on the side of the student athletes. Like, I believe that they have every right to earn revenue off their name, image, and likeness. And if an MMR wants to pay them for that, I believe it's a legitimate business purpose. That might be the simplest response I can give.
Sam?
I'll take a very textualist interpretation here because lawyer. If you look at the way that the House settlement is written, and if you look at the history of the House settlement, if you look at kind of the history and the fact that the associated entities and individuals term, and I meant to bring this up earlier, that was not the first draft of the settlement. First draft of the settlement said boosters. First draft of the settlement said boosters and said boosters very, very broadly, where, it would have impacted, if I wanted to enter into an NIL deal with an athlete, I have Boise State season tickets. With that, I pay, as part of that, I pay, I do a required donation to Boise State Athletics. That makes me a booster under those interpretations. It was far too broad. Judge Wilkins said it was far too broad. That's why we have the associated entities and individuals turn now, because Judge Wilkins stepped in and said, this is way too broad. You cannot do this. It impacts too many people. There's too many objections over this. You have to narrow this down. And now we have this narrower but very ambiguous, clearly term, associated entities and individuals. And I believe the intention here is to make that a lot more narrow It's to exclude a lot of entities that would have otherwise been included and really kind of really limit it to what the target of the settlement was, which is boosters and collectives. Of course, that line gets really blurry because the MMR companies are in some cases kind of taking the place of collectives, but at the same time, the MMR companies are representing, it's similar to Mike with your company. They represent thousands of athletes at hundreds of schools. They have relationships with them. It's not one individual school. It's not like PlayFi, even though they have this NILSU initiative at LSU. It's not like they're doing it because they're LSU boosters. So I think if you look at if you look at kind of the text of the House settlement, if you look at the intentions of the House settlement of this particular term, I don't think MMR companies fall under that.
Yeah. It's interesting because I think that when we talk about circumvention, it's not, to all the points that you guys raised, it is not that the MMR company is going to overspend, in my view, especially given Learfield's current acquisition. However, it could certainly be a way for money to funnel in from a booster-led company or a booster-led organization that is now coming through an MMR company that is on top of this dollar figure. So for me, I actually do, this is extremely unpopular and unlike me, I actually kind of side on the side of the CSC NCA group because I do think that there's so many instances, conceivable and plausible instances where the transactions are done at the request of the university and at the direction of the university and the athletic department personnel. Like Don mentioned earlier, that so many of the boots on the ground staff for these MMR companies do feel part of the department. It's part of the charm. It's part of why you do it. It's part of why they're there. And it's so easy to see the situations that I think the spirit of the settlement was meant to outlaw of, okay, the person who owns the local, car dealership is already given through the university to try to get the revenue share number up to where it can. How can they do more? Well, they can do more by increasing their sponsorship through the MMR partner and having that money funnel back to more athletes. That's conceivable. It will happen. And who's to say that's wrong? Valid business purpose, all those different things. And that's where the antitrust conversation comes in. Who's to say that's wrong? Who's to say that boosters shouldn't be able to do that? But I do understand the spirit of the ruling and the settlement and the language in there that they're trying to curb, because I go back to what I said before. If the 20.5 is supposed to be part of essentially multimedia rights and the monetization of everything around the athletic department, then theoretically, if things were done right, and this is where, again, Learfield being bought by a private equity firm, I think things are headed this direction. The MMR partner will be buying those rights from the school. If the school has paid the athlete for it and the MMR partner is the one with the right to go activate it, they would be buying the rights then from the school. And so then you have a valid business purpose for sure for MMR partners to sell that for whatever it's worth, but that's not necessarily money funneling back to the athletes, which is what the House settlement was trying to say, what's fair, what's not fair. So I actually do side with the CSC on sort of the interpretation of what is an associated entity and why does that matter. But that doesn't mean that the settlement itself stands up in court and is not an antitrust violation, as we talked about before. So it's complicated and it's a little bit nuanced. I think if the settlement can be taken at face value, I understand the associated entity clause being relevant to MMR partners. But for all those same reasons, I can see why the House settlement should just probably be challenged in general.
And that brings us right back to collective bargaining.
Drink.
A longer conversation for another show, maybe another week, another lawsuit. We'll be back at it next time on Unilateral Decisions.